Hello and welcome to the Kenneth Vercammen Law Office podcast, the NJ Laws Tube. In this edition, we discuss defending the municipal court and traffic court matter. Let's see, too often lawyers throw up their hands when a client presents a ticket involved with driving while suspended, speeding, or possession of marijuana. No ticket is impossible. Now, typically, when the person's charged with an offense, they call and schedule an appointment with the attorney, and they call the office. Most attorneys will not discuss the matter over the phone because there could be issues as to inaccurate information to be provided. So we try to help our clients. They come in, prepare a little synopsis of their past offenses, and then discuss with the attorney the charges and what can be done. So Kenneth Vercammen's office is what's called a criminal interview sheet. You fill that out. The fees are discussed. Once the attorney is retained, that's when the work really begins. So first thing the attorney will do is prepare a letter of representation to the court and a request for discovery to the prosecutor or district attorney, depending upon the state. The state has a certain number of days in which to respond to the request for discovery. Discovery is not provided. The attorney needs to file a motion to compel discovery, and sometimes simply a follow-up letter to the police department or whoever handles the police discovery is helpful. If someone's charged with a traffic offense, many times it's helpful for the client to obtain on their own a motor vehicle abstract. Now, if it's a private citizen case, we'll also send a non-police officer matter. It's important to send a letter of representation to the complainant to see if the matter can be resolved, or at least to try to get discovery from them, because the police won't have the discovery. Preparing for trial. If it's an issue dealing with search and seizure, the attorney can file a suppression motion. They can file a motion to eliminate to exclude any statements taken where Miranda was not properly given. If it's a drug case, the attorney should file an objection to the lab certificate. The attorney can also prepare other motions, such as a motion for the court not to suspend a license in a drug case. That's called a hardship motion. If there's an accident, the attorney can prepare a motion for a civil reservation. When there's witnesses helpful to the defendant, a subpoena should be prepared and then served upon the witness. The court should also be notified of the witness's name so that the court can also send the notice to them. See, on the day of court, defendant should be properly dressed, arrive on time, check in, and they can also, if there's lay witnesses, see which lay witnesses are available. The attorney then will speak with the prosecutor to determine what, if possible, can be done by way of plea bargain. Certain things in New Jersey are not charges which can be plea bargained. Those include DWI, most refusals to take the breath test, and most drug offenses in the municipal court. But the issue is whether or not the state can prove its elements beyond a reasonable doubt. New Jersey has, for first-time drug offenders, what's called a conditional discharge, and the driver's license suspension is then discretionary. And for additional information, visit the website njlaws.com, that's njlaws.com, or website benotguilty.com, that's benotguilty.com, or call the law office of Kenneth Vercammen for other information, 732-572-0500, or 1-800-NJ-LAWS-7, that's NJ-LAWS-7. They're at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you and good luck.